Hi everybody, welcome to my channel, Life, Law, Bin. Hi everyone, welcome back to the channel, and for those of you who are joining us for the first time, welcome. I do have with me, I should say, a really familiar face, Nicholas Leah, and I'm so happy that he's here as well because he is a wealth of knowledge, or I should say a fountain of knowledge, and we're going to pick his brain today in terms of securing a commercial and civil pupillage. So, Nicholas, thank you so much for joining and making time.
Absolute pleasure, Leah. It's so great to be on the channel. Obviously, I've watched it before, and we worked brilliantly together when we were on the Aegis Committee, the Association of Grazing Students last year. I always spoke about how great you were as our podcast officer, and you did some great work with the marketing, and we were facing difficult circumstances all online during the bar course year. Not easy, but I think we had a really successful time on committee, and so I'm great feels great to be back and to be speaking with you today.
Yeah, absolutely. I think we did a fantastic job as a committee, very ambitious committee, and I think we did an absolutely brilliant job. Now, before we actually jump in, I just want to share with our viewers a fun fact about yourself. Now, Nicholas, he does a bit of stand-up comedy and impressions at universities. He did it at universities. He also did it at some events and some student venues. And that's on a lighter note because I actually came across some of his work on Facebook, and it was absolutely fantastic. It was hilarious, actually. And on a more serious side, he's also one of the founders of the Young Bar Mentoring scheme. So you probably might have heard about that. And although we're not talking about that today, please do check it out, and we'll definitely have a video sometime in the future on it. So Nicholas, let's get started. Please talk to us a bit. Give us a brief introduction into your journey into law. We do know you have some extensive educational experience, but we're keen to hear about it.
Well, that is certainly true, Nia. Well, I could be described as something of a perennial student or a never-ending student, though fortunately the end is in sight because I start pupillage later this year. I'll just go through it, as quickly as I can, but explaining, if I might, along the way, why I decided to keep studying and how I think that's benefited me. I started off studying history in London at UCL, and I've always found that history was my favorite subject at school. I think it's a great grounding for a lawyer. You learn the skills of analysis, research, having to deal with large volumes of material, familiar skills that I think a barrister uses day to day. And then I decided I hadn't had enough of undergraduate history, so I wanted to do a master's, and I wanted it to be specifically a research focused master's where I could basically take forward my interests. And I looked at the legal history of slavery, which I'm still looking at, and there's a lot of interesting work that's come out in the last year or so, alongside other parts of British history. And so I took a 2-year master's at Oxford, and it was at that point where I realised that although I'd done some work experience within solicitors' firms, actually I was quite interested in exploring the bar, and I was able to do some mini pupillages for the first time. Then I'll talk about those later. And then after that, of course, the obvious thing is you have to study law, because you can't, unfortunately, become a lawyer without having studied law. It wouldn't be easy if you could. But you have to do a GDL, and I did that at City University. I really enjoyed the GDL. You get a holistic, I suppose, overview of the key foundational modules of a legal degree in 1 year. It's very intense, but I found that enjoyable, and I went straight on to do the bar course last year, and that's of course where we met. We were on different bar courses, but we were on the same track at that point. And then, having not quite had enough of education, I decided that whilst the GDL was great, I would probably benefit from a little bit more substantive legal teaching. So I applied to various LLM programs, and I'm very lucky to have got into one at Cambridge. So I've been doing that this year alongside various other things that we'll no doubt talk about. But ultimately, education has been a big part of my sort of narrative to the bar. I think it hasn't certainly hasn't held me back in any sense. I think it's been useful to talk about on applications and in interviews. And it's really helped inform me the sort of things that I enjoy, and I think hopefully will help me when I actually start practicing.
I think it will definitely help you. I always think that sometimes even doing studies outside of law definitely helps in terms of your analytical skills. Critical analysis is always key, and there are some key transferable skills as well. So I must
Yeah.
ask, do you then think, obviously off the back of what I said, do you think that your extensive educational background assisted in any way in obtaining pupillage?
Yeah, in obtaining pupillage, I definitely think so. First, I should say it's absolutely not a prerequisite to do so many years of study in order to get pupillage. There are various pathways that applicants can take, many more practical than what I chose to do. But of course, it can help. And I don't think any educational experience where you've thrown yourself into your studies and hopefully done as well as you can, I don't think any of those experiences would hold you back. Some chambers, of course, do look out for strong academics, and particularly on the commercial bar side, because a lot of the work of a commercial barrister is paper-based, is written advocacy. There's a lot of complex material often to get through, be it a construction dispute or a financial services dispute or whatever it might be. And I think the complexity of the issues involved necessitates a rigorously academic approach to the law, and also, of course, the work that you're doing. So I think that's benefited me in evidencing that I have those skills, both on an application form and then when I get asked about it at interview. But it's something also that will help, with getting onto the courses you want to do to get to the bar. So getting onto the bar course, I was lucky enough to be offered a scholarship from Gray's Inn. I think that my educational experience has helped me to get that. But obviously, I recognise that there's lots of things that you have to do to show that you are serious about a career at the bar. Education is just one of them, but I certainly think it helped me. And, I would always encourage people, if they're thinking about furthering their studies, to take it seriously. But it is expensive. And if there is funding out there, then definitely apply for that, because it's helped me at every stage as well.
Brilliant. So we know now that in a certain way, academics did play a role in securing that pupillage. So beyond
Definitely.
academics now, do you think you can outline any work, whether legal or non-legal experience, that you believe aided those applications as well?
Yeah, of course. I'll start with non-legal. Perhaps some of those will be a bit more interesting because they're slightly niche. Both of my parents have a background as business people, so I guess I grew up around an entrepreneurial, sales-oriented culture when I was younger, and I definitely think that has laid the foundation for my interest in the history of commerce, the history of trade, and also commercial work at the bar. So, already when I was younger, I was familiarizing myself with concepts of buying and selling, concepts of product liability, insurance, things like that, actually are really, really important at the commercial bar. So I was, assisting my parents with their small business when I was growing up, and that's something that helped me. A few other experiences worth mentioning. I was a sort of commercial analyst, I think that's the right term, at a software development startup before I began my master's, and I spent a few months there. And it was really interesting to see, I suppose, the origins of a business model that was spun out of a university project, and seeing those things come to life. And obviously you have both the technological software side and the commercial business development side, the side I was in, but it gives you a sense of how a business operates from sort of start to hopefully, an end goal of growth. And that was a really important insight for me. And then a final experience I might want to talk about, non-legally, I think, is that I was a debating coach at Brixton Prison as part of the Vocalise programme. And I certainly found that in applying for pupillage, this was something that chambers are really interested in. I got involved because as a member of Gray's Inn, I'd heard a lot about this programme. It was initially founded by a student member of Gray's Inn, I believe, about 10 years ago, actually. It's older than you think. And it was a really great way for me to hone the skills that are necessary at the bar. Of course, you need to be able to debate and argue, but actually how to impart them to others who may be doing it for the first time, who may have themselves never debated, or if they have a long time ago. And you get the opportunity to go into a setting, a prison setting, that you might not otherwise do. I certainly know that going down the commercial and civil track, I'm unlikely to be doing much criminal work. I know that my chambers do some criminal appeals to the Privy Council, but it's not the mainstay of what they do. So that was a really interesting experience. And then turning quickly to legal experience, beyond the obvious for the bar, mini pupillages and court-martialing, which I did do, as I mentioned before, was interested initially in becoming a solicitor. So I did various experiences at law firms, some small law firms that were regional based in my hometown of Newbury. And that was a really interesting insight into smaller practice. And then some larger firms in the city. There were two firms that I did vacation schemes with in 2016 now, I think it was a long time ago. And that was a great insight into the life of a commercial solicitor, the culture of a big law firm. And I certainly enjoyed it, but I thought, on reflection, that my skill sets are best suited to the work of a barrister, which is more autonomous, more independent, more often more, in court and advocacy oriented. So I think actually being able to distinguish between the two professions allowed me to articulate better my interest in the bar at interview. And without those experiences, I might not have known actually why I really, really want to be a barrister. And then, of course, as I said, mini pupillages, absolutely a necessary thing to do. I've done several of them, and I think that, they're all worthwhile.
Absolutely. And I'm glad that you highlighted that those experiences were key, doing work in solicitor firms, because I think some people still struggle on that question, why do they, why do you want to be a barrister? Or why
Yeah.
do you think you would be a good barrister? And I feel like one of the key things you need to know is the role of a barrister. And, how can you differentiate between being a barrister and a solicitor? So I think that's very helpful, and I think that's very handy information, because sometimes you do need to experience certain things to know that that path isn't for you. So, Nicholas, I know you've undertaken a significant number of mini pupillages. And do you think that these mini pupillages placed you in a better position to obtain pupillage?
Yes, definitely. I should say that, I did actively seek to do a number of mini pupillages, but what transpired was a lot more than I anticipated, because some chambers, as part of the pupillage application process, get you to do an assessed mini pupillage, and that it is a prerequisite for a number of chambers that you've done a mini pupillage. Sometimes they're not assessed, but usually they are. So, I started to accumulate all these mini pupillages, and I did do quite a lot, but certainly they are really useful for a number of reasons. I think the first thing is it helps you gain exposure to different areas of practice. When we're thinking about the role of a barrister, I think, the first thing that jumps to mind usually is the courtroom experience. And certainly that's true of a lot of areas of the bar. And, I spent time marshalling a judge at Winchester Crown Court, and I got a real sense of the criminal bar and the role of oral advocacy. Not the case that that's what a barrister does all the time. Certainly in other areas like civil and commercial work, there is a lot of paper-based advocacy, writing opinions, drafting pleadings, and other advice that you will give along the way. So seeing that firsthand, actually what a barrister does day to day is really critical. And I've always found that on many pupillages, you have generous members of the bar that will give up their time to explain what they're doing, as part of the mini pupillage scheme, and that helps you understand what they do day to day. And there are really two things that you will get exposure to on a mini pupillage. One, the written advocacy. You'll get to read through these large case bundles, often very complicated or seemingly esoteric, and I remember when I hadn't studied law, I thought, wow, this is complicated. How am I ever going to come up to speed with all of this? But I think, clearly it is something that even practitioners have taken a long time to research and get their head around, often very complex facts. But you read through these cases and you start to understand, okay, so this is what it's all about. And then perhaps more excitingly, if you're only doing a 1 or 2 day mini pupillage or a few days, you get to go to court sometimes and you see firsthand advocacy, be it claimant defendant, be it appellant respondent, and that was very exciting for me. I got to spend some time in the Court of Appeal on a really interesting case. And I think, it was probably the most insightful experience I've had on a mini pupillage, because we spent 3 days there, and I was just watching all day, effectively, the style of advocacy employed by various barristers, how they interacted with the bench, the questions that judges would ask, how they would intervene. And it really brings it all to life and makes you think, oh, this is wonderful. This is exactly what I want to be doing in the future. So doing that really helps. It will help you articulate better what areas of practice you're interested in. You'll help you understand the role of a barrister. And if you're asked about it in an interview, you can better explain what it is a barrister does. And of course, it will just, I think, generate a real enthusiasm for the role. If you've seen it live, you'll know much better than if you've watched some series where perhaps it's slightly embellished or not as realistic as it might otherwise be. You'll really know what it's all about. So 100% mini pupillages matter, but don't worry too much about doing a dozen. You don't need to do that many. It's really important you do a good flavor of different mini pupillages from different areas of the bar. And you can evidence in your application form, okay, I'm very serious about applying to this chambers because I've had experience in this area, or I've had experience in other areas and I didn't really enjoy them as much, and this is why I want to apply here. And I think that will benefit anyone applying this year very much so.
Yeah, I agree. And I think also it does help with that why chambers question. That question
Yeah,
could be the dreaded question for some who are struggling really and truly to write an answer that obviously distinguishes itself from other applicants who are simply relying on the website. So I definitely think that undertaking many pupillages for sure also helps with that. Now I know as well that you've done fantastically well for yourself in mooting. So let's talk a bit about that. How important or beneficial is mooting when applying for pupillage?
well, again, with mooting, with mini pupillages, with pro bono work, they're all important, but not one of them is the be all and end all. You have to try and, I think, get a flavor of all of them at some point. Mooting, I think, is essential because it's probably one of the best reflections of your potential as an advocate, in that it's a simulation, effectively, of a fictional case, and you have to do everything from start to finish. You get the fictional scenario, you're given a side to argue for. You need to do the research, and then you need to prepare your submissions and put them into a skeleton argument, and then ultimately deliver them in front of a judge or series of judges. So it is a really good reflection of your potential as an advocate. I think when you're applying for pupillage, chambers will be interested to know, if you've had any mooting experience or mooting success. I certainly found that chambers were very interested about my successful endeavours with the Gray's Inn Jessup team. and we were lucky enough to try not to sort of blow our trumpet too much. We were lucky enough to win the UK Jessup Moot last year. Now, yeah, last year, it's 2022, isn't it? How time flies. And we went on to get to the global sort of octo finals, a strange word, but it basically means the last 16 out of, I don't know how many teams, it was something like 600. So, you know, we really focused as a team. We got on really well. And I think that moot is very well recognised by Chambers. There are many other moots that are well recognised. You know, at Gray's Inn, they have a team they submit every year to the Viz Moot, which is a commercial moot based around international arbitration. They have other teams as well. And you'll know as well, Leah, of course, that we had a mooting officer on the Aegis committee who helped to facilitate those teams. And I think mooting really, it can be both an individually useful experience, but it also can help you gain those teamwork skills that you're going to need to evidence at certain chambers that will be interested in those skills, because you will be working as a barrister as part of a team. It often is lost on people applying that barristers do work in teams. You know, they often, they're led by senior juniors or by silks. They work with solicitors, they work with lay clients, they work with others. It's not completely in a vacuum. So you need to have those skill sets. And I think a team moot can evidence that you can do that, and you can hopefully be successful and go on and do well in moots. So I really recommend getting involved with mooting if you can.
And as we finish on that point in terms of mooting, recommending to get involved, we know that Inns of Court offer it and some
Yep.
universities. Have I missed anything? How else can people, get involved?
Yeah, I think those are the two obvious avenues. Just to flesh that out a little bit, universities, of course, you can at any stage, I think, and at most universities get involved with mooting. I think most universities will have a mooting society or organise a moot competition at some point. But if you don't have it at your undergraduate level, then you can wait till the bar course level, where there almost certainly will be mooting on offer. I was at City, and we had a lot of mooting competitions every year, individual and team, that you could get involved with. The Inns of Court absolutely are great sources of mooting experience. As I mentioned, we had a mooting officer dedicated to organising moots on the Aegis committee. They have the same, I think, at every other inn. And there are lots of team moots that the inns send their students to. Other avenues are independently organised moots. I know that there's something called like the National Speeding Moot or National Speed Moot, for example. Often chambers themselves organise moots. And they will sponsor moots, or they'll organise mooting competitions. I know the 36 group, a friend who actually was on the panel that offered me a scholarship at Gray's, and Mary Pryor QC, who I know you've interviewed, I believe, on this panel, on this show. She is always encouraging students to apply for the 36 group mooting competition, which they do every year. So there are lots of avenues. My advice to students would be, and applicants, regardless of whether or not they're studying, would be to set up social media accounts and try to follow the chambers that you're interested in, the Inns of Court, because they will share updates about any mooting opportunities. And just reach out really to the mooting officer of your Inn of Court, within the, whether or not that's within the education department of the Inn of Court or within the Students' Association. There will be someone who can direct you to what's going on, and you really, really should get involved as much as you can.
And that's true. We do live in a really tech savvy world. So by a few clicks of a button, you'll probably see numerous opportunities. Now, let's not
Yeah.
be shy about it, Nick. You have been super successful with the Jessup. So I only think it would be befitting for you to provide us with some top tips that person should be aware of when preparing for a moot.
Okay. I'll do my best. I think three top tips stand out to me. One on general organisation, one on timing, and then one on style of mooting. By way of general organisation, I recommend that when you're doing your research, that you think about reducing the research and the points of law to 2 or 3 submissions and no more than that. And the reason why is in a moot, you usually only have about 10 minutes. It's not long. As I say, it's a simulation of, it's certainly not a representation of a courtroom experience. I mean, there will be some instances where you're making an interlocutory application where you've only got 20, 30 minutes to make the application. But generally, mooting is very restricted. You don't have much time. So limit the points that you're trying to make, but hone in on the key points based on clear research and clear submissions. And doing the basics well when you're organizing your material will really help. So structuring those submissions, emboldening them when you're writing your skeleton argument, so the judge will know clearly what the submissions are, signposting them as you actually deliver these submissions in the fictional court. All of that will assist the judges in understanding what your submissions are. It'll help you organize your thoughts and really just make sure that you're keeping to time. And then that's my second point, is in terms of time, do not think that I've got 10 minutes, I'm just going to prepare your submissions that last the 10 minutes, because you will have questions, people will intervene. And in my experience of the Jessup was people love to intervene. Almost every second you make a point and then you have to answer another question, and it's very easy to sort of get frustrated, to get thrown out of your notes, as it were. But don't see it as that. See it as an opportunity to develop your submissions, to entertain the curiosities of the panel. But for goodness sake, please keep your timing as concise as possible. Leave a good sort of 3 or 4 minutes out of those 10, if it were a 10-minute moot, to answer questions, because you will get questions. And the worst thing that can happen, I've seen this done, and I've done it myself, as we all have, you don't get to the end of your submissions and you think, I've not done my job properly. And that's the worst thing that can happen. And then the final point is just on style. I mentioned it just now, not showing any sense of frustration, no irritation. You really, engage with the bench and their curiosities. They could be some very silly questions about, where would I find that counsel? Or, you've just told them it's on page something, but then you have to tell them again. That's fine. They just want to find it. Help them get there, and they'll be pleased. But do not show any hint of frustration. I think that's the best thing that worked for us as a team. I would say that we represented Gray's Inn, and none of us had any sort of Jessup-like experience before. Many of these teams around the world have, real sort of university-based coaches. It's a whole module as part of their degree. They take it incredibly seriously. There are rumours they actually live with each other for the duration of the competition. We certainly didn't do that. We were in a national lockdown. But the trick, I think, that worked for us was that we just tried to be as amicable, as helpful as possible with the bench. And whenever they asked a question, we would say, we're grateful for the question, and we would answer it directly. We wouldn't try and come back to it or avoid it. You want to answer it head on, and hope that the judge then goes away and lets you get on with your submissions. But that's mooting for you, and you've got only a limited amount of time to make the impact you want to make.
Absolutely correct. And I know that many mooters get really frustrated with judicial intervention. They do see it
Yeah.
as a nag and a pain, but I think it's actually one of one of the best ways to actually show the judge or the bench that you're in command of your papers, and also a way to persuade them. So I definitely think that those are some excellent tips, because we do see many really good advocates that are mooting do get a bit frustrated. And as you said, they just want to get to that section of the bundle, so help them.
Cool.
So let's talk
Absolutely.
about any other extracurricular activities that you took that you believe aided those applications as well.
Yeah, there are quite a few things I could mention extracurricular wise. I think the first thing to say is many of the applications I wrote were on Pupillage Gateway, and I believe that there is a section dedicated to where you can outline your positions of responsibility, leadership experience, etc. So I recommend that the experiences I'm going to mention now would go in that sort of section, but you might want to draw on a few of them in the main body of some of the questions you get asked, because they will be useful evidence of the skills that chambers are looking for. But I think we're going to turn to some questions about that later. In terms of my own experiences, I was very involved with student societies. I always have been. I've always enjoyed representing and being part of committees. And I set up, when I was an undergraduate, with a fellow future pupil barrister, actually, Jemima Lovett, who, shout out to her, who's a very good friend of mine from UCL, who we both set up this society called the University of London Legal Forum. It subsequently became the University of London Law Society, and it's sort of changed its name quite a few times, actually. But it's in its, I think, 6th year of existence. It was founded, well, going into its 7th year. It's founded in 2015. And it was designed for students of any background, non-law or law, any year of study, and really to help those interested in careers in law to get a sense of what it's like. And we would organise big forums on topical legal issues such as the Human Rights Act, Brexit and the legal consequences of Brexit, at various venues like the Houses of Parliament. We had Sir Keir Starmer, the current opposition leader, as one of our speakers once, and it was amazing. And so I think getting involved with those sorts of student activities are really good examples of how you demonstrate working within a team, individual initiative, handling responsibility, alongside deadlines like your essays and your exams. And I've tried to do that at every stage of my student experience. Other work would be sort of academic. I think we just spoke before we started this interview about some of the teaching I've been doing recently. I'm fortunate enough to be a visiting lecturer at City University in public law. I started that role actually during the bar course last year, and I've continued it into this year. And it's been a really good experience. The dual existence of being a student and a teacher at the same time is quite strange, but you can use that as evidence of deep interest in the law. And I think any form of coaching or teaching is perhaps the best way to truly know if you've understood something about the law. If you can impart it to someone else who doesn't know anything about that particular area of the law and they get it, then I think you understand it too. So chambers recognise that. They were always interested to hear about my experience there. And more generally, my advocacy experience, we mentioned Vocalise. I was involved with the debating team in Oxford, and I did some debating within the Oxford Union. But the comedy and impressions sets, which I used to do, I still do as much as I can. I'm hoping that will be a feature of my sort of other half of the bar. I can do that alongside practice. They really are interested in that. I think having things that set you apart from people will shine out on your application forms. And we're all different. We've all got unique experiences. Don't be afraid to show them off on your application form, but obviously think about, okay, well, what is the experience? How is it relevant to the sort of skills that are required of a barrister? And it's very clear that being a stand-up comic or an impressionist, when you're in front of a difficult audience, often of only about a dozen people, which I remember at the Edinburgh Fringe, you have to show resilience. You have to show that you can think quickly on your feet. You can keep an audience on side, and you don't sort of, you don't get bothered by the frustrations of people who aren't necessarily enjoying what you're doing, and that's going to probably be a reflection of some of the advocacy that you'll come up against in life. So all those experiences I've just mentioned were really useful for me when I was applying last year.
Indeed, indeed. So what we have now at this stage of our discussion is the nuts and bolts of your experience, etc., things that you would have employed on your application form and potentially spoke about later on in the interviews. Now, let's really talk about the practicalities of preparing and drafting, etc. So this section now will be really focused on pupillage advice. So let's start with the beginning. Why are you interested in commercial, civil, and public law?
Well, there's a lot of areas there. I think because I studied the GDL and I only had, you know, a 1 year along. If you don't include the current LLM year I'm doing, I only had 1 year before I actually applied for pupillage of proper legal education, substantive legal education. So for me, I wanted to gain exposure to as many areas of law as I could, because it's hard to say at this point, what areas I find, really, really interesting, because I haven't, had as much legal, either educational or actual real experience in those areas. So I think, that background meant that I wanted to apply to chambers that offered a whole range of commercial and civil work. I was very, very keen to have a chambers that to apply to chambers that offered public work as well. It was one of the areas that I did well in on the GDL. As I said, I've been teaching it this year at City University, and I was really pleased, when I got an offer from Three Hare Court, who I think basically do just about everything on sort of commercial and civil, on the commercial and civil front. They also have some niche areas like sports law, appeals to the Privy Council I mentioned earlier, which is really interesting. And so I think being open-minded, wanting exposure to lots of different areas, meant that I was, keen to apply to places where that would be possible. And I'm looking forward to getting started.
Brilliant. Now let's talk about that prep stage. So can you describe the preparatory stage you employed when applying to chambers?
Yes, certainly. So, I mean, I've mentioned earlier the sort of experiential, if you will, the work experience and the placements, that are important in preparation for applying to chambers. But I think what's really important is the slightly more dull administrative organizational stage, which goes in to those applications. And I hope that viewers will recognize that it is a slog, but it's important that you're well organized throughout this process. Something that helped me is I first of all went through Pupillage Gateway timely, because today you can start submitting applications through Gateway. And I wanted to find out exactly what chambers are offering, what pupillages, for what start dates, and I would put all of this information into a spreadsheet. And even if I couldn't, I think you can only apply to 20 chambers on Pupillage Gateway. Even if I couldn't apply to all of them, I just wanted to have that information, that raw information at my disposal. There are some very helpful directories like Chambers and Partners where a lot of this is actually put there for you. But they're not all on Pupillage Gateway. They're not all on these directories. So sometimes you have to independently research, and there are quite a few chambers that I applied to that were not through the Gateway. Most of them are, but you have to look around. So yeah, having a spreadsheet where you can organize all of this material will really help. And then something that I found really useful is I would go on the websites of all of these different chambers, and I would look for the criteria that they were assessing students by, or assessing applicants by. And I would copy and paste that criteria into a separate document. And then when I was actually writing my application form to those chambers, I would keep cross-referencing my application with that criteria and thinking, okay, have I hit this one or have I not? And where have I evidenced that? It was a great piece of advice given to me by my, I suppose, pupillage mentor at Gray's Inn. I really strongly advise to do the same. It helped me this last application cycle enormously, because I knew, okay, I need to demonstrate this skill set and that skill set. I'm a bit lacking on that skill set here. How can I strengthen or evidence that in another place? And then I think getting someone else to read through your application form is an absolute necessity when you're preparing to submit it. I think the old saying that getting something done well ahead of the deadline stands true, and it will allow you chance to get others to read your application form. The Inns of Court do have a service where they will get independent barristers to review your applications with you. I recommend taking up that service. It's really, really helpful. And getting the administration, getting the organization right will just mean that you're in a clearer mind about it, and you can do as well as you can.
I totally agree, because I feel like if you miss that first step, then it's going to be chaotic.
Yeah,
from there. So
absolutely.
what are the most important tips that you think applicants should be aware of during this stage, during this written stage of the application process?
Yeah, so the written stage, and the obvious thing is to tailor your application to the specific set. Um, I'm now, as you know, Leah, and you mentioned very kindly earlier, a mentor as part of the Young Bar Mentoring Scheme that Rosanna and I set up. And I mentioned this to all of my mentees, that you really need to ensure that a member of Chambers picking up your application form thinks, right, this is meant for us. Whereas if they think, well, this could have been sent to any number of Chambers, then you haven't done enough to set it aside, and demonstrated that you really are interested in that specific set, and you've done the research to show why. So tailoring your application form is important. The ways you can do that, I used, for example, doing some research, going on the Chambers website, following them on social media, looking into the things that they've been doing recently, and even a basic thing is seeing what awards they've recently received, or perhaps individual members of Chambers have received, will be a good amount of evidence that you've actually been looking them up, and okay, that they're leading players in this area, or they're rising stars in that area. So doing your research, and you can maybe mention that in a question as to why this Chambers. I'd often use that as the final line as to why that was good evidence of me wanting to join them and start my career in such a setting. So I think if they've got some certain accolades and awards that are worth mentioning, then it is something you could do, and that will set them aside from any other Chambers you might be applying to. The second piece of advice I would give is make sure that your answers to the questions align with the criteria that the Chambers set out on their website. That criteria is there for a reason. It's there, I hope, because every member of the pupillage committee is marking the applicant on the basis of the criteria. And so if you know very well what you're being assessed by, it'll allow you to hit those criteria as well as you can. Finally, I think really important is quality over quantity when you're writing an application form. It's very easy to tell a Chambers, I've done all of these things. When you're asked about demonstrated time, you've worked in a team or something. I've done all of these different things. That's great, but what you're really doing there is you're just listing lots of things. What you really want is to hone in on a few examples and demonstrate why that particular example has the makings of someone who could reasonably succeed in a career at the bar. It's not a time for you to list off everything you've done. I think that the Pupillage Gateway application gives you a good opportunity to summarize your work experience, to summarize your, you can do a sort of, when you download the application form, I remember it's all there, all the mini pupillages, legal, non-legal work experiences. So you can put those in. You don't need to avoid them, but don't list them in the specific questions, and don't fill that section with lots of material. It has to be quality over quantity. And a way to do that is to structure it clearly, 2 or 3 paragraphs, trying to make 2 or 3 clear points, not lots of different points, just so the reader is absolutely certain, okay, this applicant has understood what we're looking for, and this is easy to take away. I now know exactly, they're interested in this, or they've done this. That's great. And they'll probably ask you about it if you get to interview, but they're more likely to interview you if it's a well-written, clear, well-structured piece of application writing than one that's, I just want to tell everything. That's not the way to do it.
Yeah, no, definitely. So I now have a question for you because different pupillage processes sometimes tend to be slightly different. So
Yeah.
I really want to ask you a question about the potentially written assessments, because sometimes you do get feedback
Yeah.
year on year that some persons have written assessments. Did you
Mm-hmm.
yourself have to undertake any written assessments, like drafting or yeah, like drafting an opinion prior
Yeah.
to the interview stage? If so, how do you think applicants can then score highly in those assessments?
Yeah, I did do several written assessments. I think applying to commercial, predominantly commercial and civil chambers, they will get you to do them. Because, as I mentioned before, a lot of the work of a commercial barrister is paper-based, is drafting, is writing, is sifting through lots of material. In terms of doing well, there are quite a few things that I think can help you hit the marks that will stand you, set you aside, and stand you in good stead. Firstly, read the papers very, very carefully. Sometimes chambers will send you things a few days in advance, sometimes a few hours in advance, sometimes an hour in advance, and you think, oh, how am I going to read all of this and understand it? But read the papers really carefully, because you really need to understand what's going on. The biggest mistake I've made in some interviews is, frankly, I didn't really understand what I was meant to be arguing, or I was slightly confused as to the point of law that best served my side of the argument, because I hadn't really come to grips with the papers as well as I could have done. And I learned from that. And then I started to spend a little bit more time. I knew that there was a lot in those papers that was frankly not relevant, a lot of background facts that were not relevant, but cutting through to the salient points really matters. But let's say if you had a 2-hour assessment window, and you with a written assessment, and you're asked to draft an opinion, a very quick opinion, or a few points after reading those papers, I think it would be wise to spend 30 to 45 minutes within a 2-hour window reading those papers carefully. That might sound like a lot of time. It might sound like, wow, I'm not going to be able to write much, but the quality of your writing will be better than just getting started as soon as you can, not really knowing where you're going. And I cannot tell you how much it helped me just having a clearer sense of what was going on. Every set of papers is different. They all have their unique challenges. They're not so unbelievably challenging that you can't even make an attempt. But it's important you get that base layer right. The second thing is a bit like what the bar course tutor would recommend. And those who aren't applying this year on the bar course, if you're at undergraduate stage or the GDL stage, you can still do this. It's numbering your paragraphs. It really helps with the clarity of your writing. It will help the reader understand where you are in terms of the logical flow of your paragraphs. And it's just a really good tool. It's so obvious. It didn't occur to me maybe the first year I applied for pupillage that was such a good idea. And I really wish I'd done it sooner, because it just helps whatever you're doing. Bearing in mind I was applying as a GDL student, I hadn't really, exposed myself to these sorts of legalese practices. It really helps you just organize your writing and make it more clear. So that's another tip. And then finally, I think try to write as clearly as possible. I always enjoy reading Ernest Hemingway, because he's possibly one of the most concise writers there is. He could tell a story with very few words. He had that famous story in 6 words, I believe, once. But a draft, a legal opinion, a piece of advice is not an academic essay. It's not your opportunity to show off how much you know about the law, how well you can analyze and synthesize your thoughts. You need to do that in the preparatory stage, when you're actually researching it all. But when you're writing advice to a client, you want it to be clear and concise, and you want to tell them the answer as quickly as possible. What is it that they need to do, if anything? Do they need to provide you with any more information, or where do their chances sit? So, being clear and concise will help. You don't have much time in a written assessment. I absolutely understand. I think there's some of the harder parts of a pupillage application process, but getting the basics right will just make sure that you're able to actually get to the end of the exercise, because often that's one of the problems. If you haven't sort of thought about all of these things, you're rushing at the end to finish. Your conclusion doesn't make any sense. You haven't even got a conclusion. Maybe you haven't even turned to the third point that you were asked to advise on. So just getting the basics right, reading the papers really carefully so you absolutely understand what's going on, numbering your paragraphs, and then writing as concisely as possible. It will really help, I promise.
I'm glad that you spent some time speaking about that because I think sometimes in your hurry to get stuff done, you forget case analysis, which is just simply
Yeah.
key questions like, what am I acting for? What do I need to do to prove certain things? What
Yeah.
is the opposing side's strengths and what are my weaknesses? And I think it's easy to do that when you're especially competing against the clock to get certain things done. So, Nicholas, I'm grateful for your advice on the written stage. I will